So they did the viewing.
Also set for hearing this morning was defendant's motion for payment of costs and appointing neuropsychologist to assist the defendant in preparation of the defense. That was filed on August 14th. The next day, August 15th, JSC has filed a response to the motions for payment of costs and appointment of a neuropsychiatrist. Paragraph 10 of the JSC's response reflects that JSC will not be participating in this hearing. Mr. Owens, good morning. What is your position, sir, with regard to Ms. Boone's pro se motion?
Right, I got right. James Owens, you said?
I'd like to abandon that one, but substitute it in for two other motions for the appointment of a forensic psychologist, Dr. Julie Harper, who was on this case previously. I believe she saw Sarah Boone about 6 times at the Orange County Jail. She was working under the direction of the original counsel, Mr. Padilla, who I believe had the case for about 2.5 years. And I think it was set for trial, ready to go, and then at the last minute he withdrew. I tried to call him a couple of times. Haven't been able to find out what went on. I have talked to Ms. Cashman, the last lawyer. But we don't need this neuropsychologist that Ms. Boone had requested, but we do need a reappointment of the forensic psychologist, Dr. Julie Harper. I've spoken with her a couple of times.
So a lot of people were asking, why was Sarah Boone writing a motion asking for a neuropsychiatrist? I don't know why, but apparently when this attorney came on, he withdrew that motion, that request, and he's asking just for a forensic psychiatrist. And that makes sense because he's using the battered woman's syndrome defense. It's also known as battered wife syndrome or battered spouse syndrome. There's a new term coming out that's common now. I hear battered paramour syndrome. Go figure, y'all. So he's going to be using that. He has to have an expert to set the foundation to explain to us why that's the case, right? We need that. Experts usually, in my opinion, I've seen them make literally all the difference.
Last week, I text messaged her
Good evening.
4 or 5 times this weekend. She is in agreement to handle the case, to reopen her file. She has sent me her records. I have reviewed them. I've met with my client. I think my client meets
He's
the
already
criteria
got a
for
forensic
that spouse.
psychiatrist.
I believe Dr. Harper, after she gets a chance.
Sorry, it sounds like a forensic psychologist already saw Sarah Boone and then something stopped in that process, probably because it's disruptive to change attorneys and have all your files moved again and again and again, especially with public defenders who have a high caseload. So this guy is on it so far. He's like, oh, she saw this person. I know this person. I'm going to text him, get him back on the case fast. Usually you can't do it this fast, right? This takes time to appoint someone. And then the issue with the expert is they can't just say, oh yeah, I'll go testify. Testify to what? They have to actually review your case. They have to review whatever it is they're going to testify to and take the time to do that. And then, otherwise it's a very poor, weak expert. If they're just walking up, and we have seen this in cases where they say, well, in general, this is a general rule, and they won't testify as to the defendant. But in this case, they want her, I think, to actually be evaluated. Okay, let's go.
To re-engage with my client, spend some time with my client, and hopes that she's going to be of that opinion.
That's it.
In addition, I believe it's necessary for the appointment of a crime scene reconstructionist and death investigator, Dr. Michael Berkeley, who is from my area, Pensacola.
Wait, appointment of what?
To be appointed.
Wait.
The appointment of a crime scene reconstructionist and death investigator, Dr. Michael Berkeley, who is from my area, Pensacola.
Crime scene reconstructionist. Ooh, that is going to be interesting. A crime scene reconstructionist. Well, what are they trying to reconstruct? We have a video. They are alleging, okay, I promised you new information. Here it is. Ready? They're alleging that she didn't just happen to have the suitcase there. The allegation is that they had a very big fight, and before she saw him that day, she brought it down. That's what they're saying, because she had some kind of intent. Now, if it's true, I have no idea if what I'm saying is a fact or not, but it's been repeated consistently by sources that I usually find fairly credible, that after they say something, kind of comes out. The other thing we know is that at a period of video, she was dragging the suitcase around with him in it. And that's why when they did the investigation, they were talking about the contusions and bruises on his body, because after she put him in, she was dragging him around. And I think even maybe, I don't know, I'm not sure about exactly how or where. I think there may have been stairs involved. That is nuts. She's strong, right? So she can't say, oh, I'm not strong enough to do this. She definitely did that. Tony says he's going to get into the suitcase and open it with his fingers. I think that was the idea, right? We know that he drank, smoked weed, and he was probably not sober that night. That's what she said, and I think that that's probably true. Let's just take that down for a second. Okay, so I think that that's probably true, and they were probably just messing around. That's what stoned people do, right? It sounds ridiculous, but if you add, drugs and alcohol to the mix, something that sounded ridiculous a minute before, it's suddenly kind of not so ridiculous. This is what happens. Grown adults are acting like children. I'm not commenting on whether or not it's good or bad, but obviously in this case, it's all fun and games till someone dies in a suitcase. Oh shit! I accidentally changed my my desktop with my fingers. Oh, gotta fix it real quick. This is ridiculous, my technical difficulties. Key control left arrow. Okay, this is what I must have done somehow. Okay, what's key? Windows key. Okay. Oh my God, I got it back. This is insane. I'm crazy. This is crazy. Oh, I'm nuts for doing this. I somehow misplaced my, nice webcam that has a bling light and all that. And I'm using the internal laptop system. So my sound is probably total crap, and my visuals, obviously, not the best. And I do apologize for that, you guys. I'm really sorry, but I'm small in the corner most of the time anyway. So let's go back to them.
Is who I am recommending to be appointed.
What was his name again, sir? I'm sorry.
Michael Berkland. I filed these judges yesterday or last night. I don't know if they're in the court file yet.
I did not see them this morning. I did see the motion to dismiss.
Can I approach them in?
Yes. State, have you seen them?
I just saw them briefly this morning prior to the
Morning, sir.
hearing.
Thank you.
He's been following
The only
this
thing I saw in the
therapy.
court file, Counselor, when I was prepping last night, was the motion for statement of particulars. They filed on September 2. I have not yet seen these motions.
Judge, I also filed a motion for additional discovery. I don't know if that made it through as well.
Was that also filed yesterday, sir, sometime in the evening?
It was filed.
Sorry, don't forget to like and subscribe, pretty please, so I can keep making these for you. PD2, he's like,
At
he's gonna
8:30
bite me.
yesterday morning.
So I have a motion for statement of particulars filed at 8:10 yesterday, but I do not have the motion for additional discovery filed 8:34.
I don't know why
We'll do self-return.
the portal was not able to post that, because they were filed one right after the other.
One's in the court file, the other three aren't.
My settings are muting my camera.
Certain things auto-populate and certain things have to be accepted.
Okay.
So he's
Statement of
reviewing a
particulars
motion.
and the additional discovery were filed yesterday morning.
Most attorneys e-file online, and right now the judge is. So it used to be like 5 p.m. was the deadline, right? You had to get something in by 5 p.m. As soon as COVID hit, everything went online. A lot of hearings went online. Here, obviously in criminal cases, these guys show up in person. But a lot of civil cases, a lot of things where, a lot of quick hearings are not done in person anymore. And anyway, the point of the story is that filings are done online. And usually if something's due on Friday, it's due at 11:59 on Friday. I mean, technically 5, but that's what we do all the time. We're like, it's due Friday. Well, we're staying until midnight, right? And then we're filing at 11:59. I can't tell you how many times I've done that.
The motion to
But he's
appoint
still
a
taking
crime
it,
scene
right?
reconstructionist and
The point of explaining all that is that he didn't have time to read it before because it was filed late the night before. So the judge is seeing it for the first time. That is the point. While you guys watch, I'm going to grab some tea. Keep watching. Petey and I are, move your tail, buddy. Petey and I are going to make some tea. Tea? Yes, he wants it too. Let's go.
investigator and the motion to appoint
There's
forensic
Petey.
was filed at 6:10 p.m.
I do see that. As the court previously identified, JACS chose not to participate in this morning's hearing by virtue of their response filed on August 15th. They are not here. Your motions for these various experts report that they were sent to all persons on the service list through the e-portal. But I don't know how I can address these this morning without having JACS here. So I will endeavor to coordinate a hearing for these as soon as practical. I understand these need to be addressed. Be advised, this is a trial week for the court, as is next week, but I will do my best to endeavor to try to get these heard as soon as possible.
Judge, and I filed my notice of appearance on Friday,
Yes, sir.
and I've spoken with Dr. Birkland 2 or 3 times this weekend. The state was able to provide me with some discovery. I think once I filed my notice early Friday morning, I think the state provided a lot of discovery to me. I provided that to Dr. Birkland. I believe he has the autopsy. We cannot find the autopsy photographs, which he says are critical. We cannot find the crime scene photographs, which he says are critical to his evaluation. So I know time is of the essence. We've got people working on it, but there is some additional evidence that we need.
State, what's the status of the provision of the autopsy photographs and the crime scene photographs and providing them to counsel?
We provided all of those things previously, obviously, to the defendant, which has been greatly discussed already. When Mr. Owens' notice of appearance came on the case, I instructed my assistant to go ahead and send copies of the document discovery, which is easily available to him, just so that he could quickly have that and not have to worry about getting that from his client or whatever. I believe we also sent notice to as well that if he wants additional copies of the autopsy and crime scene photos or any other pieces of digital evidence in the case, that he just needs to provide USB and we can go ahead and burn that for him. Again, this is in addition to what's already been provided to the defendant in this case.
Okay, do we have a time frame where we might be able to get that information to him?
If he wants to come back to my office, we can do it this morning / this afternoon.
Is your office in the building?
Yes, it's in the courthouse.
Right there. Come out the front door, make a left.
Okay. I don't have a USB with me, but I'll find one. This morning, we'll get that done.
Okay, I appreciate you both. With regard to the motion for additional discovery filed yesterday, September 2 at 8:34 a.m., State, give you the opportunity to review this.
I just reviewed it just now here in court this morning. The state was going to request an opportunity to respond to both this motion and also the motion to the statement of particulars formally and in writing, given the lack of time we've had to prepare to make a formal response.
Sure. And how much time, Counselor, would you like in order to file a response to the motion for statement of particulars and the motion for additional discovery?
Look at our
I would
smile.
ask for at least a week.
Any objection?
No objection.
Okay, all right. The state shall file a response to both the motion for statement of particulars and the motion for additional.
Okay, I just want to go through a couple of comments with my dry mouth here. Okay. She got lucky. All right. So Jem says she is an evil person. She should have to face the consequences. It's sickening. She wants justice, but she maliciously and wickedly murdered someone. And murdered. Not supposed to say that, YouTube. I think I'm going to have to make a Patreon so I can not censor myself and put up the materials and the videos and the non-censored versions and just bleep them out for YouTube. I don't know. It lets you edit alive after you put it up. So I guess I could do that. I murdered him. Okay. So while laughing, yeah, she's laughing about it. Now, was she laughing about tricking him to get in? Or was she laughing because she actually had intent to end his life? I don't know. I think she was drunk and laughing about tricking him to get in and just being a generally mean, verbally abusive person, and maybe passed out and then woke up and thought about how to present the story, because when we listened to her on the 911 call, she sounds like a child who came up with an explanation that they're trying to sell. You see, I fell asleep. So it makes me doubt that she did fall asleep. It's hard to say. I don't know on this one. Okay. I think we might find out more at the trial, but her attorney's attempting, if I understand right, he's attempting to suppress this video, which means the jurors might never see it. And that would change the story a lot. It would change their perceptions a lot if all they get to see is George Torres and his record as well as hers with the DV. Right? That would definitely change things. So we'll see if he's able to do that. Crazier things have happened in these cases. Okay, so Tip the Mama says, it's okay, especially since you got the sound bugs. Oh, thank you. Thank you. I almost muted myself again, but you know, I was in a court hearing this morning and I was in Teams. Welcome, Cooper. I love this little bird. He's just so sprightly and fun. So I was in this court hearing via Teams. Step up. Petey, step up. He said no, so he bit me, but he did it. The body language says no, which means I'm going to get a bite, right? Mild, just a little pinchy. Okay, so I didn't want to be heard under any circumstances, so I muted my mic from my system, just in case I didn't want any system sound to disrupt the hearings, printing, and things like that. And PD jumps on my screen, of course, and probably can do some other things. Okay. It says for PD, it's really fun after dark because they stop screaming about the sun setting and screaming at everybody they hear and just chill out, you know, and snuggle with me. And PD especially is very snuggly, as you can see. He loves it. And he's very funny. And his antics can be really fun. Just not when he's screaming. Okay. So Tip to Mama says, you're right, Tony. Like the tiger, but about more important things than just breakfast. Sorry, terrible joke. Oh, Tony, oh my God. Tip to Mama, did you really just say that? I'm sorry, Tony. All right. Okay, Tony says she had no lawyer last week. Now she has two. And what? Tony? Who's the second one? I saw the first one, but I am not seeing, when did the second one come on? Like, what? I really do believe, if I had a law degree and the ability to take it on, if I'd passed the bar and I saw this happening, I might do it not for fame, not for attention, but just because it's not fun to see anyone bulldozed by the system without any objection, right? I do agree she's a terrible person, but we can't have a system that works without a push on the other side. Always a balance, right? Always a balance. So I'm glad that she has help. Are you sure it's another lawyer and not a paralegal or something like that? Okay, we're gonna keep going down. I'll find out. I thought there was a little forget my bird's butt. Really, Pete? Okay. I cannot believe she got another lawyer. Well, I do think, though, that there will be people who are like, I'm going to stand in the way. There's somebody without a lawyer, I will be that lawyer. There are people out for a cause. And, I've done it with cases. Going for a cause is so good, even when it's not practical. Tipton Mama says, it's crazy. I think maybe they want the challenge and they're bored and they want the fame. Yeah, maybe. Maybe. Tony says she should have no lawyers. She's treated the others like crap. Well, we'll see. I mean, the judge is not going to force them to stay on the case. If they, I have a feeling that if they don't get some level of respect from her, they're not going to stay either. These guys are private, and they were asked though by the judge if they were pro bono, and he said no. One of these guys, I can't say they because I only saw the first guy who appeared in the hearing. He said he is not pro bono. So how's he getting paid? I think I saw a question about that. Oh yeah, who is paying her attorney? Good question. I do not know. I don't know. She absolutely comes off as completely diabolical, doesn't she? And Tony says they will owe her. Probably got a percentage of the books or movie in the end, maybe. You never know. Did you know that? Jem says, did you know that she also closed her little son in a suitcase and had CBS called her and was investigated? Yes. So, yes, I think that we might have talked about that in one of the other episodes. This is number 4. We've done 3 before. We touched on it in another live. Yeah, so she knew, for me, it wouldn't be a thought in my head. I wouldn't see a suitcase as a potential weapon. It didn't occur to me. But she has a mind that looks for potential weapons and things. And she saw it and she thought about it. And I think she absolutely knew that she could get some kind of leverage over him. And in terms of just analysis of her, and we've done a lot of deep dives on her, I think she's very power oriented. And she kind of orients the world in a quid pro quo sort of way in her mind. And she thinks that if she just demands in the right way, she'll get the thing in return. It's really diabolical is a good word. And Tony says, yeah, in 2016, okay, I didn't know the year. Thank you, Tony. She was fascinated with the suitcases, apparently. Yeah, what's with her suitcase obsession? Love says, you're doing a great job. We all have technical tips. Thanks, Love. I am not very technically oriented. I was when I was a kid. Oh my God, I was on the edge. I had the first beeper. I had the first text typing on AOL. I knew all the things. I wrote HTML. I'm just saying. Now, geez, please give me an iPhone with pretty buttons. Love says, Petey's so pretty. Oh, thank you. He is beautiful, I think. I think this bird is really beautiful. He's very, if you're an ASMR person, you would adore this bird half the time and just want to screech with him half the other half. He's just really, he goes in the back of my neck and just kind of tickles. It's so funny. He might do that routine tonight. Petey's got all the attention. Everybody's talking to Petey. Okay, well, we pin those. We'll keep watching.
Discovery no later than the close of business 5 p.m. on Tuesday, September the 10th. And if
Yeah.
hearings are necessary, we'll coordinate those. With regard to the defendant's pro se motion for payment of costs and appointing neuropsychologists to assist the defendant in preparation of the defense, the court's going to deny that as moot based on Mr. Owens' representation. With regard to the motion to appoint crime scene reconstructionist and death investigator and motion to appoint forensic psychologist, State, are you intending on filing a response to these?
No, we're going to take no position on those points.
Okay, all right. I will have Ms. Berrios, I'll ask the clerk to see if we can push these through the portal today so that Ms. Berrios can reach out to JICS and see if we can get a time frame on when they may be able to provide a position statement or a response to those motions, and then we'll coordinate a hearing respectfully.
Judge, I'm going to want to add one other forensic psychologist, make a request. You know, I want to make sure that there's not an issue about my client Sarah Boone and I manufacturing the defense. And there's a second doctor, Dr. Michael Brandon.
Spell that last name for me, sir.
Dr. Michael Brandon. I don't know if
B-R-A-N-N-E-N?
he spells it B-R-A-N-N-O-N. He was the forensic psychologist in the Marsha Thompson case. That was the Palm Beach County first-degree murder where she shot and killed her husband, shot him 9 times. He was laying on the couch and was acquitted of first-degree murder back in July of this year. That was a 2019 case, so that took a while to get to trial. But Dr. Brandon testified that a battered woman's experiences affect her perception of imminent danger. And that's going to be a question in this case, whether or not Sarah Boone, at the time of her actions, was facing imminent danger. In addition, Dr. Brandon said victims of repeat violence may fear death in situations others would not.
And?
I've tried to reach out to Mr. Brandon this weekend unsuccessfully. And my intent is to reach out to him. I'm hoping he's going to respond. He claims on his website that he responds within 48 hours. That's the only other witness I'm going to need an appointment for a forensic psychologist. So 2 forensic psychologists, Dr. Julie Harper, Dr. Michael Brandon, and then the crime scene reconstructionist, Dr. Michael Burton. And then in addition, I would like Billy Lane, who's seated in the audience. He is the investigator on the case. Because of the claims that we're making that she's a battered woman, we need evidence to corroborate that. So there's a lot of history between her and Mr. Torres involving the apartment complex, which is in Winter Park. That was 4 years ago. The ownership of that apartment complex has changed hands, so it's going to be somewhat problematic trying to get information about who all the tenants were that may have witnessed some of the violence involved in these two, as well as we're trying to get together the 911 calls that Sarah made and others made about the disturbances between that couple. So he's got a lot of work to do as it relates to running down witnesses. In addition, we're trying to get arrest reports of the prior domestic violence arrests of Mr. Torres, as well as the officers involved and their body cams to see if there's any evidence on the body cams that would show injuries to Ms. Boone. So we've got a lot of work to do, but I believe it's necessary for us to prove a viable defense of battered spouse syndrome, that we have cooperation. It's going to take a little bit, but I do need the appointment of that expert. He tells me he's already on. I'm going to have to file something else because it was under Sarah Boone. Now, as the attorney of record, I'm going to have to file something. He says he's still got plenty of hours to work under that original cap. So I'll be filing something today or tomorrow as it relates to that. But that's the only other. Of course, I've been retained, so I'm not going to make any claims for attorney's fees. I'm not making any claims for travel costs, just for these witnesses.
The JCS has already approved, I believe, $10,000 in investigation fees and $1,000 for other costs associated with Mr. Lane. That was at one of our previous hearings. Now, that was when Ms. Boone was representing herself pro se. I can't imagine JACS may change their position with regard to those costs since they've already said yes, but file it and we'll try to tee it up for hearing as well to see if they have any position, or it can just be, the order can be modified to extend to you as counsel for Ms. Boone.
Thank you.
All right. That takes us now then to your motion for continuance filed that was filed on August 30th. Courts had the opportunity to review that motion. Any other argument or statements with regard to that motion? Mr. Owens.
Judge, I reviewed the state case law relating to continuances and the abuse, palpable abuse of discretion when the court does not grant it, but it is critical to my theory, our theory of defense, battered spouse syndrome. And as you know, that takes time to develop, especially when the motion basically speaks for itself, but we're in a time crunch. Essentially, the trial is set for October the 7th. I have to provide a notice of intent to rely on battered spouse syndrome 30 days prior, which is September 7th, which falls on a Saturday, so I believe that gives me till the next business day, Monday, September 9th. But still, 6 days for Dr. Julie Harper to come back out and visit with Ms. Boone, coupled with this other potential forensic psychologist, Dr. Michael Brandon. He's not going to have time to do that. They've got to establish a rapport with her before they can run the testing, spend the time with her. And it involves some extensive history. Obviously, that couple was together for 3 or 4 years. I still haven't peeled back all the layers. I've tried to go through it, but as you know, something like that is going to involve several instances of domestic violence that did not involve law enforcement. That was just between the two. So we've been going through that. We're trying to get some medical records where she was stabbed by Mr. Torres in the leg, and some other evidence. It's just going to take some time, coupled with the fact that I've got to get Mr. Lane to get all this other objective evidence, witnesses, and 911 calls, and arrest reports, and provide that to the 2 forensic psychologists for them to help formulate their opinion as to whether she is, in fact, a battered spouse. In good faith, I believe she qualifies based on my spending 3.5 hours with her Labor Day, yesterday, as well as the other 4 times that I've met with her.
There's another video. I will check it out.
I spoke to Mr. Cordelia, but I believe that was probably going to be where he was going to go. I was not, involved. I don't believe you were involved at that time. Or may have been.
Welcome, if you're just joining us.
Okay.
Yeah.
But I think it was almost ready to go. And for whatever reason, he withdrew at the last moment.
Right.
And then here we are.
She thinks he's so interesting.
I think it's...
The funny thing is, we're all teasing her about being self-important as we watch and break it. So I was saying, as a person who works at litigation, like, well, the amount of time I spend analyzing it, I probably could, do some motions on her. It's so funny. Everybody wants to watch and see what happens, but nobody wants to deal with this trick.
If we're not allowed to present the defense, that we believe we have a viable claim, and I would respectfully ask, I'm not asking for, I think most times you come on a homicide case, you would need at least 6 months. I'm asking for 1 trial cycle, 2 trial cycles, sometime at the end of the year or first of next year. I can be ready. I think that will give enough time for our experts to visit.
I'm asking for an extension.
And
I haven't seen this yet. But what did the judge say before? He said there will be no extensions to trials in October, right? New attorney is not, except for, emergent good cause. And a new attorney is not good cause.
Formulate their opinions. I'm sure the state's going to want to take the deposition. I think they may have the right to hire their own forensic expert to go out and interview to see if they agree. But that's just going to take a little bit of time, Judge. I'm thinking 2 or 3 months, and we'll be ready to go. I'm not asking for a long continuance. The good thing about it is Mr. Cordelia has done a lot of the work. My understanding he's taken just about all the depositions. I believe they've been transcribed. I haven't gone through all the discovery. She's got the 2 banker's boxes. She has not gone through all the discovery. We've tried, but we have not made it. My understanding is a lot of the 2-hour interrogation with the Sheriff's Department has been transcribed. I haven't reviewed that, but we do have a problem with that interrogation. Now, that's why I made the request about the policy. Our policy in my county, Santa Rosa County, is a little bit different. And based on my discussions with her, we feel like I'm going to need to file some motions relating to that. So, because of that, but ultimately because, yes, could I be ready for trial on October 7th? I believe I could, but not without the battered spouse defense, because I don't believe my experts would be ready. And so that's instrumental in our defense.
State Attorney.
I guess the state would just respond to a few things. Part of this battered spouse defense has been previously investigated with
Sorry,
several
what's happened in the OJ case?
previous attorneys, and in fact, the state did retain an expert, Dr. Tanya Warner.
Jen, what's what happened in the OJ case? And by the way, I didn't want to shortchange it by being in a hurry and just hustling through. I wanted to be there with you guys. So we're going to get back to the OJ case that's happening. Maybe even this weekend. We were on the night chapter. I mean, my God, I got to get like back into this and you guys got to come with me. So, all right, let's finish.
Who's on the state's witness list in this case in anticipation of a potential rebuttal
power trip. She's all about power trips.
Attempted battered spouse defense. The state's position would be that we would impose a continuance at this time. However, the state's not opposed to setting another status hearing sometime next week, possibly, where we could address this and to see if there has been any movement, anything that would either change the state's position or potentially the court's position as well.
I don't think the state's thinking it through, Judge, because if we
He's the
wait a
prosecutor.
week, I've got to file a notice of intent to rely
And he
on.
just went from his case just completely changed this trial. His strategy is going to have to completely change. He was working with first he was working with an attorney. Then he was working with a pro se defendant. And now he's working with two new lawyers. Like, what? What are they going to do? They're going to have to meet and confer, talk about what exhibits they agree on, how this works. They're going to be submitting real emotions that are, experienced and have thought in them, good law. So, yeah. And they're going to be all over this, right? Because it's so, they took it knowing the situation, and it's so in the focus right now. I mean, I think they're going to be on it. Cooper, where are you, buddy? Where are you chirping from? Oh, hi. Oh, he was on my chair, making me feel like a Disney princess. What the heck? While I do true crime. This is true crime in the fairyland with parrots. Okay. Down the rabbit hole.
That's on Monday. We can't wait a week. The time has expired. If the judge doesn't continue it today, he wants to have a conference next week, but it's too late for him.
What's your response to the rule requiring these battered spouse or battered wife syndrome defense 30 days prior to trial?
You have to give it.
Right, but I mean, clearly when that rule was created, it contemplated that there would be sufficient time to prepare for that defense within 30 days of trial, which is why they gave 30 days, which is why the Florida Supreme Court said it, 30 days, not 60, not 90, not 120.
But in good faith, you can't file a notice of intent to rely on the defense of battered spouse syndrome if you don't have a supporting psychiatrist, forensic psychiatrist, that makes that.
Oh, interesting. So in order to officially use the battered spouse syndrome, he has to file something called a notice of intent. Now, I'm not an attorney, but I do work with these things, so I'm just going to tell you for entertainment and educational purposes. You have to file something called a notice of intent, which lets the court know that you're going to pursue this defense. You have to basically have the defense on file. You can't just go in like it's on TV and say, Your Honor, we didn't do it. And if you find we did do it, it was because we were crazy and we weren't there, right? You have to be congruent. You can't pick incongruent defenses. So sometimes they're not even going to let you use a defense like this if there's no evidence for it. So the judge, this new attorney just said to the judge, Your Honor, we have, in order to file this notice of intent, we have to file it with evidence. So that means they have to have the psychiatrist or the psychologist spend enough time with her to write up this review and explain why this person really believes she has battered spouse syndrome. And then he needs to be able to have time to file the notice of intent to and serve it on everyone. And that I had a situation where I served something late last night, and then I fell asleep and woke up just a short time later, going, "Oh no, did I e-serve everyone?" And got out of bed and did the thing. It's very serious. So you're swearing under penalty of perjury that you have a certain amount of time to do this, and so anyway. If you shorten the time, there's going to be declarations, I think, and all reasons why you had to. Anyways, it's potentially appealable, I guess is the point.
I just can't say, hey, we're going to rely on it, and I'm putting you on notice. I've got to have some kind of authority. I'm not an expert. I think she meets the criteria, but I'm not a psychiatrist. I'm not a psychologist. I can't make that opinion. I've got to have an opinion from an expert before I can follow that in good faith. I can't do it without Dr.
Hey, Tony, I'm sorry. I'll chat again. You can watch it, without me if you want to. I'm going to talk. That's the point. It's everywhere without me. So, Tony, smug, I think it is the single word for what you're describing, and you're describing it well. She wears a smug face, and she can't seem to hide it. It's what makes her hard.
She needs more time. Dr. Brandon needs more time.
All right, thank you.
Great.
State anything else?
No, you're right.
All right, thank you very much. All right, Mr. Owens, it seems like you've already started to dive into the case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case.
Yes.
Jem, no, the state is not paying for this attorney. They're not paying for this attorney. This is a private attorney, not funded by the state, the tax, or anything, which is, that's the question. He answered her ad. They answered her ad and said, sure, we'll work on your case. He says he's not pro bono. So they are asking the state, though, for the money for all this, for these experts. The state is paying for the experts, right? They're not paying for these attorneys.
I'm sure you've read the court's June 28th order, which was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflicted out lawyers' basis for withdrawal, and why the court ultimately made a decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel by virtue of her actions. This case has been pending for some time. You advised in your motion to continue that you met with Ms. Boone on 4 different occasions, that you just met with her yesterday for 2.5 hours. You were aware of what the order identified, which was in paragraph 6 of the order and adjudged portion, that the trial specially set for October 7th, 2024, and that it would be not continued for any reason, absent extraordinarily good cause, and such extraordinarily good cause would not include the retention of counsel. You haven't been appointed in this case. When you undertook this assignment,
I got a comment on this,
that you were
Tony.
not being appointed, and that by your own representation.
I have wondered if he'd actually participated in getting in the suitcase, or if he was passed out and she put him in there. Now, when I say passed out, could have been from substances, or she could have knocked him out with a bat, right? Possible. He did have contusions from the way she dragged him around. And like I mentioned, we can't say she wasn't strong enough to pick him up and put him in there. So maybe he fell asleep on the couch and woke up in the suitcase. I haven't ruled that out. Like, she's like, ha ha ha, wow, I really outsmarted you. And I think what they're trying to argue, first of all, they're trying to exclude the video altogether. That's what they're going to try to do. And either way, I suspect they're going to say that she was effed up, so to speak, right? And then when she realized that he was going to be very angry, she was too scared to let him out. And that's where the battered wife syndrome comes in, I think. It's a hard sell. I really think she might have physically put him in there after he either got knocked out or fell asleep or passed out. So if when trial comes around and we hear the prosecution's side, and we get to see the discovery, and sunshine law, that's an awesome thing about Florida, is we get to see discovery. We're going to find out more about that situation and what they think she did with potentially a bat and with the suitcase, and how she might have put him in it.
You're doing this free of charge?
Well, by the way, I think it's pure fabrication, the bit about having a hole for his fingers. Fabrication. Or she wouldn't have been laughing like that. No. There was no hole.
On a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the deadlines were for the court. With regard to any of the experts, there have been multiple prior experts in this case. You already identified Dr. Julie Harper, a forensic psychologist. You advised that she's met with the defendant on 6 different occasions. She was appointed back on August 3 of 2020 under Mr. Padilla's representation of Ms. Boone. At no point in time did Mr. Padilla file a Category A witness list disclosing Ms. Dr. Harper as a testifying expert, and as you astutely pointed out, this matter was days, if not weeks, away from being tried when Mr. Padilla moved to withdraw based on the reasons outlined in the court's June 28th order. Thereafter, Dr. Charles Heller, another forensic psychologist, was appointed on February 3rd, 2022, and again on March 1, 2022. No Category A witness list was ever disclosed with regard to Mr. Heller.
I just have to say, these are not sponsors, but this is very relaxing. It's amazing. I love to chill with tea while I do true crime and snuggle with my birds. And this has this guy at work is super healthy. I tried to give it to him. He was like, no. And I read the ingredients, and he took it and drank it and got really into it. So it's naturally sweet because of the licorice and the fennel root. And sweet, there's something else in here, I can't remember. Anyway, it's good, worth trying. Aveda brand, the tea. Okay, so back to the video.
Then Winston Hobson had an undisclosed expert that had met with Ms. Boone, as addressed in open court on February 9, 2024. And as Mr. Hobson put it, that expert was not meeting with what Ms. Boone had desired or requested of that expert. There was another expert psychologist that was...
In other words, she already had some experts who gave opinions, and she just didn't like those opinions. So she's opinion shopping, right? Well, he can bring that up at trial, can't he? I wonder, can he?
Was appointed by Patricia Cashman on February 28, 2024, who had expertise.
So Patricia Cashman got the expert. Did a lot for her.
There were also Dr. Linda Dore.
He
2 times sought to be appointed, once by Attorney Bankowitz. Dr. Dore specializes in battered wife or battered spouse syndrome. Once by Dr. Bankowitz Mr. Bankowitz, on July 17, 2023, again by Attorney Hobson on January 1, 2024. Based on the Florida Supreme Court decisions in Middleton versus State, 220 Southern 3rd 1152 and 1176, and Bargo v. State, 221 Southern 3rd 562 at 569, there's a 2-part test determining the need of experts. We're not going to be addressing that today, as you've sought to file these other motions that I haven't had really the opportunity to address. And JCS is not here to have the opportunity to review those.
Brian, thank you for this comment. Really an important comment. He's saying I just want to take a minute, really acknowledge this and break it down. Tony says the only difference between George and Brian is that Brian ran away and George fought back. So I think what you're trying to say, Tony, is that when Sarah got angry and violent with Brian, her first husband, Brian would just leave. But George would escalate. And so there would be DV scenes and police called, if I understand right. That's what you're getting at. So really good comment. Thank you for bringing that up. And if you're just joining us, guys, please like and subscribe to my channel. So Pete and I, and Cope, of course, can keep bringing you content, and we'll keep following Sarah Boone. Okay, OJ's attorney suppressed the precise evidence that the jurors never got to know. Yes, I see what you mean. Yeah, they strategically suppress evidence. It's true. I see it. Tony says she wants complete exoneration. That's why she didn't like the experts. Yeah, I mean, they're probably, it's just my guess. I don't know. I can't diagnose anyone, but I think maybe they want to say she has some personality disorder and she is like, no, F you. That's what I think. Like, wouldn't you guys guess? Maybe something, little dead rabbit kind of going on there a little bit. Vibes, right? Okay, let's keep going.
In Ramos versus State, 75 Southern 3rd, 1277, and 1281, by the Florida 4th DCA in 2011, citing to Lawson v. State, 884 Southern 2nd, 540, also by the Florida 4th DCA in 2004. In that case, defendant Ramos changed his defense counsel at least 4 times while this case was pending, with the latest change of counsel occurring 2 to 3 months before the actual trial date. There's no record evidence showing that any of Ramos's previous attorneys had provided ineffective assistance, and the defense had already moved for 4 continuances to prepare for trial. Similar to the Ramos case, Ms. Boone has played a prominent role in shortening the preparation time for trial, as set forth in the court's June 28th order. This case has already been continued 16 times. As of the date of your filing of your notice of appearance on August 30th, this case has been pending for 4 years, 6 months, and 4 days. On June 7th, this case was specifically set for trial on October 7th, and the June 28th order by the court specifically speaks for itself and evidences how Ms. Boone played a prominent role in shortening the time for preparation for trial when her 8th attorney, Ms. Cashman, withdrew. Ms. Boone reached the point where her right to adequate time for preparation of trial is counterbalanced by the right to the effective administration of justice. As of August 30th, when the notice of appearance was filed, there were 37 days until trial commencing in this matter. Considering the prejudice of the denial, Ms. Boone has already availed herself to 4 different attorneys that were not conflicted out, Padilla, Banquets, Hobson, and Cashman, and only has herself to blame for the withdrawal of those 4 attorneys based on the representations in those motions and the findings in the court's June 28th order. Discovery has been reviewed with Ms. Boone by prior counsels, as established by counsel's representations in various hearings, and prior counsel's motions for attorney's fees, all of which were filed in the month of August of 2024. Ms. Boone has had discovery in her possession since August 5, 2024. The digital discovery that the state seeks to admit at trial was provided to Ms. Boone on August 9. Although you were not court appointed, sir, the court's done its own research with regard to your expertise. You've been barred since October 15, 1986, with a duly elected public defender of the First Judicial Circuit in the state of Florida from 2009 to 2012. You've tried over 100 cases to verdict throughout your career. You've met with Ms. Boone on 4 occasions, as outlined in your motion, not including the meeting that you had with Ms. Boone yesterday. As to the battered spouse syndrome defense, you still have time to file the appropriate notice in accordance with the rule. In considering all the factors as set forth in
You still have time. I'm not giving you more. No.
185,
I told you.
189,
No more time.
Florida 2nd DCA 2020, your motion for continuance is
They have all
denied.
night.
Matter, this trial is still set for October 7th. We will have pre-trial.
Figure it out.
The
Contract someone else. That's basically what you have to do. Sit there and be like, well, then, I get it.
pre-trial in this matter, or trial case management will still be set for
I
September 26th at 9 a.m.
I have to call someone.
Judge, a couple of things.
Maybe you call me.
Number one, I have a full practice. I've got a docket day this afternoon in Santa Rosa County before Circuit Judge Scott Duncan. I've got 12 clients that are pending. I've got other people covering it, but I do have a full docket. If we set some of these hearings involving my motions, could I be allowed to hear by Zoom?
Any objection?
No, Your Honor.
The only request that I would have, sir, is the rules of general practice require a notice regarding your appearance. If you could just file a motion and provide a form order, I'll sign it, and you can appear virtually. There's no reason for you to drive all the way down from Santa Rosa County for all these hearings, when we can appear virtually. JACS, I imagine, will be appearing
That's what we were
virtually for
talking
some
about
of these
earlier.
motions with regard to the
Because
experts. So as long as you follow
usually
notice
through
in advance,
Teams
there are no
or-
problems with that.
Judge, in that pre-trial order, it mentioned, I thought, that the state attorney was supposed to meet with the defendant.
if you know a case number, if you know the department number, just like if you know where to go, if you go into a courtroom while it's happening, you can go in right now. Well, maybe not right now because it's 8 p.m. But during business hours, you can go in and observe court proceedings. You can do that. If you're a attorney in the matter and it's not, and it's a trial, a type of hearing that is, not typically done virtually, you can do what he's saying, submit a request, an official request to the court to attend virtually, or a notice. It might just be a notice, which I filed those before, notices to virtual remote hearings. So usually in California, it's a standard form for it. I don't know about Florida, how that works. Different counties have different things too. Okay, so
And the defendant's investigator
It's
can
sleepy.
review all the digital evidence from the order. That's the way I read it. They were supposed to sit there all together and watch every potential
Right? That's
video
what we wanna
exhibit
know.
the state was going to intend
who's
to
paying
introduce
him?
at trial. That has not happened. I think today was the deadline for that.
We may
I'm
talk
not
about it
extending
after.
that because I'm going to need to look at the evidence.
With regard to the
Interview.
digital, the deadline, you are correct, sir. The deadline was today, based on the August 5 order. If it did not happen before then, as I outlined at the beginning, there was a change to that process. A thumb drive was provided in open court to Mr. Lang on August 9. He then provided it to Ms. Boone, a thumb drive of the specific digital evidence that the state is seeking to admit at trial, based on the witness and exhibit list that was filed under seal on August 9. Ms. Boone had the opportunity to review that information at that time.
All right, I'm going to ask for more time for me to review the digital exhibits they intended to release. I don't know if they've been redacted. I don't know if they were the originals, but I'm going to need to look at that. I went to the jail yesterday. I had to let them know in advance that I was coming. I believe my secretary had emailed them and said I wanted to bring in my laptop and my phone to view evidence and whatnot. I was not allowed to bring in my laptop and phone yesterday for 3.5 hours. So I didn't get done a lot of the things that I wanted to get done within that period of time. Probably would have stayed there a lot longer if I would have had that capability. So I would ask for some more time to be able to look, for me to look through the digital evidence as to what they're, I assume it's being redacted. I know some of the audio in terms of clients, comments my client made, comments the officers made, some of it is, in my opinion, improper to be presented before the jury. So
Very
I'd
shy.
like some extra time to be able to do that.
State?
I'm not certain, is he asking for a continuance again? What is the extra time that he's seeking?
What is it you're asking for? Extra time to do what?
The way I understand the order, I'm looking at paragraph 4 of the scheduling order and notice of hearings that Judge you signed off
For
on
what
5th.
specifically?
Paragraph 4, the state's digital evidence will be reviewed with the state's investigator, the defendant's investigator, no later than September 3rd.
They want to review all the digital
This
evidence
viewing can't be
already
done in
gave to
advance of
Sarah.
September 3rd deadline. The state shall provide the defendant USB drive with the station. They never viewed it with my client in its entirety. As the order states, they were to do by today. So the state attorney has failed to comply with the court's order. I'm saying I haven't had a chance to view it either. Can we reset that deadline?
Close the door.
On August 9, Mr. Owens, we had a different hearing. And at that hearing, we addressed the digital discovery review. Mr. Lane was here. There was a USB provided in open court, and the August 9 order and notice of hearing identifies a change to that August 5 order. Specifically in paragraph 4, prison break investigations. By and through investigator Billy Lane shall take possession and custody of the USB jump drive, which contains the state digital evidence, tendered in open court on August 9, 2024, and shall provide same to Major Malik X. Muhammad at the Orange County Jail today, August 9. Paragraph 6, prison break investigation shall file with the court a notice reflecting that the discovery in the USB jump drive, which contains the state digital evidence, was provided to Major Malik X. Muhammad at the Orange County Jail according to the date and time of the transfer. Such a notice was provided by Mr. Lane and filed in the court file. It was discussed at that August 9 hearing as to the revising of the digital evidence schedule. Paragraph 8 states that on August 14th, 2024, 1:30 p.m. a hearing will be held, courtroom 12A, regarding defendant's review of the USB jump drive, which contains the state's digital evidence, the defendant's August 7th letter to the court, provided to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024. The pertinent case law is attached. On August 14th, we had a hearing, we discussed that, and we identified that she had the deadline until August 23rd to make any objections. Now, under the original scheduling order, which said this matters, which on August 5, which set the schedule for when there would be deadlines for objections, those would be extended by good cause shown. Are you seeking at this point in time to extend the deadline for a period for objections which has since expired?
Yes.
Okay. State?
No objection.
Okay. How much time would you like, sir, in order to review the state's digital evidence that it seeks to admit into evidence and tender any objections?
I've got to go buy a jump drive. I've got to take it down to his office. He's going to give me that evidence. Obviously, I need to review it with my client. I've got a flight out of here around, I think, 4 o'clock. I don't know if I can get it done by then, but I don't see the necessity of an issue, maybe a week prior to trial, whatever that is, a week prior to that Monday, October the 7th, the week prior.
State?
Ready?
I'm amenable to setting a status hearing that week.
Here's what we're going to do. We'll address any objections to any of the discovery when we have trial case management on the 26th.
Thank you, Judge.
All right. Anything else, Attorney Owens?
I was trying to make toaster strudel, and I battled with the toaster, and I think it won because it broke my thumbnail. So it's very sad.
Sure.
I'm gonna go see if my toaster strudel is toaster strudel still. Right. Okay.
State, anything else?
Not at this time, Your
All
Honor.
right. Madam Clerk's going to work dutifully to, it's already done? Excellent. I'll have Ms. Barrios, by judicial assistant, forward these to JCS and see if we can coordinate a hearing. State will have till close of business September 10th to file responses to motion for statement of particulars and motion for additional discovery. Parties having no other business before the court. Y'all can have a fabulous day.
Thank you, Judge.
Thanks, sir.
Can I have a word with Sarah?
Absolutely.
She emailed me.
I have returned the toaster strudel, and in just the perfect time, it seems. Okay, let's get this off the screen, and let's hear from her new attorney about why he took the case when he comes out and he talks to the press. I definitely want to hear that. Here we go.
A woman accused of allowing her boyfriend to die in a suitcase was back in court today.
After going through nearly a dozen public defenders and looking like she would have to represent herself, a private defense attorney stepped up to take her case. News 6's Ezzy Castro is at the courthouse with more on how it went.
Sarah Boone's new lawyer, who is actually from the Panhandles, told us that he learned about her case through social media and even court TV. And today he did ask the judge for more time to prepare for her trial, but the judge said no. Why this case?
Sarah Boone needed a lawyer. I mean, I can't imagine our system. The case is an aberration.
The new lawyer for Sarah Boone speaking to us for the first time after a hearing this morning at the Orange County Courthouse. James Owen says he will now represent her in trial next month, despite her going through nearly a dozen public defenders over the last few years. Boone is accused of leaving her boyfriend, George Torres, to die in a suitcase back in 2020.
Sarah's been sitting in jail for a while. She's looking for her day in court, and we all want justice to be served. You know, I'm a criminal defense lawyer. I've been doing it a long time. The state has the burden of proof. They have to prove their case. I know there's some strong evidence in the case.
Last week, Owens filed a motion asking for a delay, saying he plans to use battered spouse syndrome as a defense and needs more time to prepare. But the judge denied his request for delay. He also asked to bring in a crime scene reconstruction specialist for Boone's trial.
That expert was not meeting with what Ms. Boone had desired or requested of that expert. This case has been pending for some time.
And the judge told the defense and also the state that they will discuss more during her pretrial hearing, which is set for the end of the month. However, her trial is set for October 7th. Outside the Orange County Courthouse, Ezzy Castro, and Results News 6.
Okay, so that was interesting. He talked a little bit about it, right? Did we get anything actually out of that? Okay. Is this the one? This is the one we watched, right? Did we already see this one? I'm not trying to play you a picture. I'm trying to play you a thumbnail from this one.
Thank you, Candace. A woman accused of allowing her
it's the
boyfriend
same
to die in a suitcase was back in court today. After going through nearly a dozen public defenders.
Okay, that's not it. So, yeah, I don't have a lot else to play for you tonight on that. That was very interesting. Thoughts on that, what it's like to be on her defense team right now with a limited number of days that aren't going anywhere. Her up against Steele when it comes to these deadlines. The judge has made that clear. And, you know, it's the team that takes this on. Thank God. So Sarah Boone, yeah, she went from having 0 attorneys to 2 attorneys. It looks like she was pretty, you know, she went through a lot herself and she gave it quite a bit herself. And when she did it, she was, as women tend to be, more diabolical. The problem is she was also more physical than most women tend to be. She just jumped in and did both. She has entitlement, in my opinion, and she'll use anything to get what she wants. And she gets angry easily. She doesn't seem to have a lot of control over how quickly her anger escalates. So, yeah, that's my take on Sarah. And as trial comes up, you know we'll keep following it. You know we're going to keep bringing it to you. So, again, like and subscribe. Thank you for being here. Say goodnight. It's Beauty. Beauty kisses. Kisses. Peace out, guys. Stay safe. It's all good.